I heard the good chairman say that the bill as drafted, as proposed here, would not restrict the police officer's ability to do their job. I have to respectfully disagree with that assertion. I heard the chairman reference the case of Peter Riley. I believe, from my recollection, Peter Riley was convicted sometime around 1973 or thereabouts, long before I was born. Some of my colleagues can't make that same assertion, but it was before I was born. I also heard a lively conversation between my two legal colleagues here, which is always entertaining, and they talked about what is current law. And they talked about federal law, and I would submit to both of my friends that there are several prevailing case law from the United States Supreme Court and the Connecticut State Supreme Court that date back all the way to 1936, which speaks to the inadmissibility of an interrogation or a statement that was unduly coerced. One of the things that we did not talk about, and in fact, before I say that, let me say this. The state of Connecticut and judicial branch, and I challenge my colleagues to check this for themselves, has an advisory commission on wrongful convictions. And in their statement of history and purpose, it notes that although there are few cases of wrongful convictions in the state of Connecticut, few cases of wrongful convictions in the state of Connecticut. My good colleague referenced some civil liability that happens in a state nearby. Well, in 2011, this legislature passed a bill that said that any interrogation that was conducted had to be video and audio recorded, provided that the case or the crime for which the individual was suspected is an A or a B felony. So they all were video and audio recorded. And I think it's an important distinction, Mr. Speaker, because many of the cases that proponents of this legislation want to reference, the question to whether or not the confession was unduly coerced is difficult for a court to determine when it's one individual's word against another. But today, and in fact since 2011 for A and B felonies, the entire interrogation can be viewed by the prosecutor, the defense attorney, and the judge to determine whether or not it was unduly coerced. Just a few years ago, this legislature passed another law that mandated that every police officer, when interacting with a member of the public at all, shall have their body camera activated, which of course is audio and video recorded. So today, as we sit today, every single interrogation that a police officer does in a building, outside a building, on a car stop, in a park, you name it, if they're talking to another human being, their body cam is activated. The interrogation, or the interview as we like to call it, is audio and video recorded for folks to later see. And the representation was made that they are not publicly available. And I suppose in cases of juveniles, maybe they wouldn't be, but generally body cam footage is available through FOI. So I did want to mention those sort of distinctions based on the debate that I heard earlier. Regarding the bill itself, if I go through, much of this bill I have no problem with. As far as the substance of it, that being the words on the paper. And the reason I don't have a problem with it, Mr. Speaker, is because much of this bill, in fact, does not inhibit a police officer's ability to do their job, because it's already existing constitutional law, it's already existing case law, and it's certainly already existing training, and according to the data that we see, in practice in the state of Connecticut. So as the good ranking member said, passing a bill to respond to something that really doesn't exist today is really, in a way, a virtue signal of negativity towards this profession. Say this, we talk about police accountability fairly consistently in this chamber, and I've always tried to make the distinction between police accountability, that is holding police officers accountable when they do it wrong, and police restrictions. That is restricting their ability to get their job done. I think the two get conflated often. This bill, quite simply to me, is the latter. The first is good policy. Holding police officers accountable for a job done wrong is good policy. restricting our law enforcement officers from getting a job done, especially when we're talking about dangerous offenses, is bad policy. And I think this is the latter. I think that this is nothing more than a bill that will further restrict officers in pursuit of their duties, and therefore it's bad policy. And despite my best efforts, I'm not going to be able to support it. Thank you, Madam Speaker.